Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 161. Hope everyone had a good Christmas. Wish you all the best for 2020. As we've traditionally done at this time of the year, the podcast is a review of the key cases in 2019. It's inevitably a little idiosyncratic. These are the cases that I think are the most interesting, relevant or potentially far-reaching ones. One of the great benefits, I think, is a great chance to sit down and reflect what you think the key cases have been. Some of these have featured in previous best of lists as they work their way through the system. Some of them indeed may feature again in best of lists in the future. Let's see. Please don't forget, podcast is available via iTunes, on the Mayer Brown website, YouTube and the Twitter feed, Nicholas Robertson, at Nicholas ROBER11, which is also where we post out links to all the cases discussed. And as we all know, we're on Spotify, Google Play, Yahoo as well. I should say that because this podcast is quite a lengthy one, we've split it into two parts. And the second part will be out shortly, also looking at another few key cases. So, the first case to come up is Bosworth and Hurley and Arcadia Petroleum Limited and others. This is a European court case on interterritorial jurisdiction. Bosworth and Hurley are British nationals, but they're domiciled in Switzerland, or they were at the relevant time. One was CEO and one was the CFO of the Arcadia Group, which includes Arcadia Petroleum that responded in this. They're also were directors, various Arcadia subsidiaries. In 2015, the Arcadia companies commenced proceedings against Bosworth and Hurley, alleging compensation for damages suffered as a result of alleged fraudulent transactions. Those claims are contested. The question was where the claims should be determined. Bosworth and Hurley agreed that, according to the Lugano Convention, they had to be sued in Switzerland, which was the state in which they were domiciled, and they said that they had to be sued in the state in which they were domiciled because they were employees of Arcadia Petroleum. Under the Lugano Convention, very similar to the Brussels regulation, employees have to be sued in the country in which they are domiciled in relation to claims arising against them, arising out of matters that relate to their individual contracts of employment. The High Court and the Court of Appeal have both of them accepted that claims could proceed in the UK, apart from the claims alleged to have occurred whilst Bosworth and Hurley were parties to contracts of employment with Arcadia Petroleum. The case went up to the Supreme Court, which looked further the question of whether or not Bosworth and Hurley were employees within the test as laid down by the Lugano Convention. It's not in dispute the individuals had contracts of employment. But Bosworth and Hurley were running the companies. They were not subordinate to anyone other than the shareholders. So did their quote-unquote employment arrangements qualify as employment and make them employees within the scope of the Lugano Convention? The European Court found that despite the fact they had contracts of employment, the individuals were not employees within the scope of the Convention. The Court decided that in order for there to be an employment relationship, there had to be a hierarchical relationship between the worker and the employer. This is not a matter, they said, for the classification of national law. In this case, such a relationship of subordination did not exist, as the ability of the individuals to influence Arcadia, i.e. the two individuals in question, was, quote, not negligible, unquote. In other words, because they had significant influence over Arcadia, they were not viewed as employees. This subordination, if anything, went the other way around. I think the case is significant. It means that board directors in some companies, particularly where they are effectively running the show, are outside the scope of the convention, regulations, etc. when it comes to determining jurisdiction. The special protection given to employees does not apply. It remains to be seen how the English courts will interpret the significance of the words not negligible in relation to Bosworth and Hurley's ability to influence Arcadia. I think not negligible may well mean significant, but let's see what the test is that is actually applied. So that's the case of Bosworth and Hurley and Arcadia Petroleum Limited and others. Next up, Ali and Capita Customer Management Limited, and Hextall and Chief Constable of Leicestershire Police. And this, of course, is a case, or these are cases that have featured in previous end-of-year lists. These are the cases on the ongoing and hugely important litigation whether a comparison is possible for discrimination purposes between pay during periods of statutory maternity leave and pay for shared parental leave. The central issue in both appeals is whether it's unlawful discrimination on the basis of sex, either direct or indirect discrimination, or because of the operation of the Sex Equality Clause, which is implied into all contracts by virtue of the Equality Act 2010, for men to be paid less on shared parental leave than birth mothers are paid on statutory maternity leave. Factual background is relatively common. Employers here were voluntarily enhancing the maternity pay, but were not similarly voluntarily enhancing shared parental leave pay. And it was argued that since men were not taking statutory maternity leave, then it was discriminatory if employers were not equivalently enhancing any shared parental leave period. In this litigation, Mr. Ali was claiming it was direct discrimination for Capita not to be paying him at the same rate as a woman on statutory maternity leave. Mr. Hextall claimed it was indirectly discriminatory, as in practice far more men would be taking time off under the shared parental leave scheme than women. Mr. Ali won in the Employment Tribunal but lost in the Employment Appeal Tribunal. Mr. Hextall lost to the Employment Tribunal but won in the Employment Appeal Tribunal, to the extent the Employment Tribunal was asked to go back and reconsider their decision. Both Mr. Hextall and Leicester Police appealed to the Court of Appeal on that case. So, cases clearly raised similar issues and so were joined. And the Court of Appeal rejected the claims by both the individuals. In relation to the claim by Mr. Ali that it was direct sex discrimination for him not to be paid at the same rate, the court decided the purpose of statutory maternity leave was to enable the mother to prepare for and cope with the latter stages of pregnancy and then to recover from childbirth, whereas the purpose of shared parental leave was different. The appropriate comparator, therefore, was not a woman on statutory maternity leave, but the female partner of a woman on statutory maternity leave who wanted to take time off pursuant to the shared parental leave legislation. In those circumstances, a woman would have been paid at the same rate as Mr. Ali, and therefore there was no direct discrimination. In relation to Mr. Hextall's claim of indirect discrimination, the Court of Appeal said that, in effect, this claim was to be regarded as a claim for equal terms in his contract of employment. However, the Court decided that the Sex Equality Clause did not apply because the comparator's terms, in this case the mother's terms, were better because of special treatment given to the mother because of her pregnancy or her going through childbirth, and this is statutorily permitted under the relevant equality legislation. In any event, the court said that the claim of indirect discrimination, if he'd been able to proceed with that, would have failed, as in reality what he was complaining about was that only a birth mother had the right to statutory or contractual maternity pay. In any event, the employer would have been justified in acting as it did, as special treatment of mothers in connection with pregnancy or childbirth was a proportionate means of achieving a legitimate aim. The Court of Appeal also placed some significance on the fact that the right to shared parental leave was not a freestanding right, but was conditional on the mother agreeing to swap her maternity leave. Well, the significance of these cases is pretty obvious. Had the case gone the other way, then employers would have been faced with the choice of either making payments in future at the same level under the shared parental leave process, or of levelling down pay in respect of maternity periods of pay, so that they could not be relied on to improve shared parental pay. On the basis of the Court of Appeal's decision, this is going to remain something entirely at the discretion of the employer, because in the Court of Appeal's view, it's not open to disadvantaged men under the shared parental leave scheme to bring complaints. Well, the decision has been appealed to the Supreme Court, and a date for the hearing is awaited. So, Ali and Capita Customer Management, and Hextall and Chief Constable of Leicestershire Police. Next up, again, no surprises with the next time, I'm afraid, Tillman and Egan Zenden Limited. This Supreme Court decision was certainly one of the key cases of 2019. The background is that Ms. Tillman had provisionally worked for Egan Zender in the executive search and recruit business. She then looked to move, and a dispute arose as to whether or not her restrictive covenants were enforceable against her. The key covenant provided she would not directly or indirectly engage or be concerned or interested in any business carried on in competition with any of the businesses of Egan Zender which were carried on as at the termination date or during the 12 months prior to that date, and with which she was materially concerned during such period. The issue that was before the Supreme Court was whether this was a valid covenant, because it would preclude her from holding any shares whatsoever in a competitor, even if they were simply held for the purpose of investment only. The issue then arose as to how the covenant was to be interpreted. Did it really ban her from being involved in any way from passive shareholding in a competitor? And was it a restricted covenant in the first place? And if so, could its provisions be severed? I think the real significance of this case is the severance point. The issue with which the court was concerned was that, as previously understood in earlier cases, the test for severance didn't seem to permit severance in these circumstances. There was no exclusion for the purpose of minority shareholding investment only. Therefore, if the court interpreted the phrase cannot be concerned or interested in as including a minority shareholding for passive investment purposes, i.e. that was precluded, could it delete the words concerned or interested in from within a larger single covenant that provided she would not directly or indirectly engage or be concerned or interested in any business in competition, etc., etc. In order to turn an invalid into a valid covenant, a court cannot rewrite a clause. It can only delete wording from a clause, and the Supreme Court considered the case law on deletion of wording in restrictive covenants and decided on a more relaxed approach to the severance of covenants that would otherwise be held to be invalid. The blue pencil test will continue to apply. The first issue, the Supreme Court held, is whether or not the wording which goes too far can be removed simply by deleting wording. The second issue is whether there is still adequate consideration for the covenants. Where it is the employer saying it wants the covenants reduced to make them enforceable, it's extremely unlikely, I think, that will ever be an issue. Thirdly, the deletion of the wording should not change the nature of the contract so it is something entirely different from what the parties entered into. Again, it seems difficult to say how that would be an issue in many occasions in an employment contract. So this is obviously an extremely important case, and one which I think it is going to switch the focus of battle over restrictive covenants. The court has, in my view, made it easier to enforce restrictive covenants. My experience is that, by and large, most restrictive covenants these days are properly drafted. Therefore, the focus in more cases is going to be on the facts rather than on the interpretation of the covenants. It's going to be the claim for constructive dismissal, or this clause is wider than is necessary on the facts for the protection. Once the court that accepts it is easier to delete words out of the covenants, if there is a bit of the covenant that goes too far, I think we're going to see more speedy trial where the facts can be tested and fewer interim injunction battles. It'll be interesting to see how this develops. However, for now, it does mean that employers are not going to have to go back and look at rewriting all their covenants. So that they become a long list of separate covenants rather than mixing wording within a single covenant. So that's Tillman and Egan Zender Limited. Next up, Coastal UK Limited and Dunkley. This is a court appeal decision relating to the making by offers directly to employees where a collective agreement is in place, and I can tell you that the outcome came as a significant relief to employers. The legislative background is Section 145B of the Trade Union and Labour Relations Consolidation Act 1992, which says where there is a recognised trade union or a union which is seeking to be recognised, the employer is prohibited from making an offer directly to an employee where the sole or main purpose of the offer is that the employee's terms will not or will no longer be determined by collective agreement. In this case, the employer, Coastal, had a recognised trade union in place. In return for a particular pay offer, Coastal wanted employees to agree that they were going to give up certain rights in their contract. This wasn't a right to give up recognition, it was they were going to trade in contractual benefits. This offer was rejected in a consultative ballot that the union put out, and then there was deadlock. On two separate occasions, Coastal wrote directly to the employees inviting individuals to accept the relevant offer. Eventually matters were resolved, but employees argued that there had been a breach of Section 145B. They said that the offer was, in effect, an inducement to agree that this particular offer would not be negotiated collectively and would instead be determined by one-to-one bargaining. Coastal, in contrast, said they were perfectly happy to carry on recognising the union for all purpose. They were simply trying to break the deadlock. Both the Employment Tribunal and the EAT agreed with the trade union, and as a result, Coastal was looking at a fairly significant compensation payment. However, the Court of Appeal overturned these decisions. They said the legislation was designed to prevent two situations. One, where the employer offers an incentive to employees to prevent a trade union becoming recognised, and two, where the aim of the offer was to obtain the withdrawal of the recognition of a trade union's right to negotiate on a collective basis. Both of these results were prohibited by law, the court said. But the Court of Appeal said there was no basis for saying that the legislation was intended to apply to the situation that had arisen here, i.e. there was deadlock in the collective negotiations, and the employer wrote directly to the employees inviting them individually to accept a particular offer against that background. They said that if the employer was never allowed to go directly to the employees on a particular offer, then the union could always veto any offer the employer wished to make, which would be unworkable. I think a lot of employers will breathe a sigh of relief. Factual situations that may arise may be infinitely varied in pay negotiations, but the issue in similar circumstances will be whether or not an offer is designed to achieve the end of collective bargaining. In any event, the Court of Appeal has given a clear and firm ruling that where there is a stalemate, the employer is able to go to the employees. And I think if I was acting for an employer in this situation, I'd be cautious about going to the workforce too soon to avoid it looking as though the employer was trying to circumvent the negotiations. However, I think the legal position has probably gone back to what we always understood it was, i.e. that the legislation was designed to deal with the two separate scenarios identified by the Court of Appeal and not the third scenario identified by this trade union. So that's Costo UK Limited and Dunkley. Next up, we have Phoenix House Limited and Stockman. I know you're supposed to say you're never supposed to say to a client something's a really interesting case, but this is a really interesting case. It deals with an employee who covertly records a meeting with the employer and then tries to use that recording in a complaint against the employer. In this case, the employee worked for Phoenix House. There was a job restructure, there were problems around finding alternative positions, and the individual moved into a more junior role, but clearly working relationships were strained. She was summoned to a meeting because there was conflict, and she covertly recorded that meeting with HR. She did not say anything at the time, or indeed immediately afterwards, about the recording. There was a grievance and a formal process, and then she was dismissed, and then she claimed in the employment tribunal, and during the tribunal process, it came out that she'd made the covert recording. In terms of the legislative context in a claim for unfair dismissal, a tribunal may reduce the basic award of compensation to a claimant or cancel it altogether if the claimant's conduct before dismissal would make it just and equitable for them to take that step. It may also reduce the compensatory award of compensation where the claimant's conduct has contributed to the dismissal itself, or it would be just and equitable to do so. The EAT found that the Employment Tribunal had been entitled to decide that the claimant had not made the recording for the purpose of entrapment, and so it was not a breach of the mutual trust and confidence rule by itself. So the tribunal had been entitled to make only a minor reduction of compensation of 10% to reflect the employee's wrongdoing in making the covert recording. The EAT noted, interestingly, that given that many employees now carry smartphones so that recording is much easier to undertake, it is no longer necessarily the case that recording was being done for an improper purpose. They also held that, while it would be good practice to notify another party that a recording was being made, they declined to say that it was necessarily the case that making a covert recording breached the duty of mutual trust and confidence, and the employee may have legitimate concerns and reasons for making the recording, such as enabling the employee to take legal advice. While many employers will be very concerned about this, I am less concerned. Where evidence is relevant, it will not be excluded simply on the basis that it has been obtained without consent. A recording may be excluded if it is improper, for example, where an employer's disciplinary panel was covertly recorded in the closed session, the deliberation session, after the employee had left the room, and it was debating reasons it was going to rely on to come to a final decision. But there is no general principle saying that evidence obtained without going through the proper channels is necessarily excluded. I'd add, however, that in a situation where an employer and employee have a meeting and the employer's side will then discuss matters directly, it is now sensible practice for those subsequent discussions to take place in an entirely different room. I know you may think I'm being paranoid on that, but I do think it's prudent. But there's no general principle saying that evidence obtained without going through the proper channels is necessarily excluded. Secondly, if an employee would be permitted to have someone present taking notes from the meeting, is it really so different to have an employee openly recording the meeting? Whilst many employers I've spoken to dislike the idea intensely, I don't think it's a particular sin in circumstances where the employee could legitimately take a note of the meeting or have a colleague present as a note taker. The EAT commented that employers may look to add in covertly recording meetings to the list of gross misconduct offences in the contract. However, do bear in mind that just because something is included in the list of potential gross misconduct offences, it does not mean that it is necessary gross misconduct when it happens, and it must still be a reasonable course of action for unfair dismissal purposes for the employer to dismiss. So that's Phoenix House Limited and Stockman. Thank you very much for listening as always. We'll have one more annual review podcast which will look at the second half of the key cases from 2019, and then we will have a looking forward podcast, and we'll see if Mr. Fisher can repeat his clean sweep on the predictions, and then we'll be back into the ordinary podcasts with guest podcasts as usual. So thank you everyone for listening, and until the next podcast, take care.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.